Namaskar. I'm going to talk to you today on the changing contours of criminal responsibility. The reason for including this video in this module is because, as I had mentioned to you when we discussed disability and personhood, that we have recognized universal legal capacity for all persons with disabilities. This particular video is going to be reflecting upon what is the impact of this change on the way in which we have to be teaching criminal responsibility. I will, in the making of this analysis, also draw upon the philosophical and conceptual categories that Mr. Murli Karnam referred to when he spoke in terms of criminal law. The scheme of my presentation is I firstly talk to you on how do we traditionally teach criminal responsibility, then move on to seeing how this would need to change in the face of the fact that we have recognized universal legal capacity. And lastly, I want to dwell on how we need to be making for more disability inclusive curriculums and why this disability inclusion would be desirable for law teaching and for the kind of students we wish to create. To begin from, how do we teach criminal responsibility traditionally? Though unsoundness of mind figures in both the penal code and in the code of criminal procedure, we largely concentrate on section 84 of the Indian Penal Code, and therein you have, you could say, two streams in which we discuss the question of section 84 and criminal culpability. The section says that no one should be considered to have committed an offense if they didn't understand the nature of the act, or that they did not know that it was wrong and contrary to law by reason of unsoundness of mind. The question is, how do we understand unsoundness of mind? We have two approaches that courts have taken. Till about, you could say, the middle of the last century, unsoundness of mind was largely seen in a very strict legalistic kind of manner. You were trying to control people's both sane and insane impulses, but subsequent to that, the more medical way of looking at it also kicked in. So you have one approach which says legal insanity is not the same as medical insanity, and the other which defers to knowledge and expertise that we get from psychiatry and psychology and says that, okay, if they find a person to be mentally disturbed, to be mentally ill, then that kind of person should not be found to be culpable. These two approaches have carried on almost simultaneously since the 50s. It's not like at some point we were strict and other points we were more deferent to expertise from psychiatry. It's like these two kinds of approaches have carried on throughout in the manner in which Section 84 has got interpreted. When we come to the Code of Criminal Procedure, like I said, that chapter is not usually a very major part of our curriculums, but for the purpose of the argument that I have that I'm sharing with you today, it's important that we also touch upon the CRPC. And if you look at the CRPC, you'd find that primarily we have addressed the entire question of the continuance of trial or its postponement, the whole question of fitness and unfitness, of the fact of whether a person should be kept in custody or should be discharged. We have addressed the entire issue in binaries. So unsoundness of mind and how it impacts on people is either a yes or a no. It's in very black and white terms that the CRPC has addressed the issue of unsoundness of mind. So you're either fit or not. Now, if this is the manner in which we have been looking at criminal responsibility or culpability, then how has it been changed by the adoption of universal legal capacity in the Convention on the Rights of People with Disabilities? The reason why this question is arising is that people are saying if people with disabilities have full legal capacity, a capacity not just to hold rights but also the freedom to act, then a capable person should be held responsible. How can you continue to have the defense of insanity after having full legal capacity being recognized for people with disabilities? One point I would want to make here, that this contention is somewhere conflating responsibility with culpability. We can be responsible for several things, responsible for good and bad, but culpability is necessarily a wrongful thing. Now, should questions of responsibility and culpability be similarly addressed? I think is a very fundamental kind of question. If we sort of go back to the theories that Dr. Karnam was discussing with you, now one way of looking at it is the reason why you wanted full legal capacity for people with disabilities was that you wanted that they should have the same moral worth as all other human beings, that they should be responsible for the good and the bad. If that is the argument, then from the curial kind of perspective that you take of criminal law, it is only sort of logical that persons with disabilities should also be held culpable on similar kind of terms that you put forth for people with non-disabled people. The point I made to you earlier about this conflation between responsibility and culpability has also to do with the fact of that it is not like we hold people culpable for every wrongful act that they do. Very often as a society, as a community, as a culture, you may find that there are certain kinds of wrongful acts which a community does not punish. The entire realm of self-defense, or the manner in which in certain jurisdictions, you don't necessarily feel that everything has to be punished. You have a more compensatory kind of an approach. So how is it that the community should look at the wrongful acts of people with disabilities, considering that we still are battling with giving them a level playing field in the whole area of be it education, be it communication, be it infrastructure? If they have an unequal world to live in, is it only in the realm of criminal law, only in the realm of punishment that we should be treating them in the same way? So the communitarian approach that Murli Karnam referred to, or the punitive approach that he was mentioning, would necessarily also give us some level of insights on how we should be examining this question. I am also sort of making a swift reference to the question of prevention and say to worry about that if supposing, wouldn't prevention mean that if you give people with disabilities full equal opportunity of living a full life, would not that be the route to be putting in prevention, and rather than to be just saying let's remove the defense of insanity? I'm not in any which way saying that I'm asking for the abolition or the retention of the defense of insanity, because this is a conversation we are having as peers. I'm only saying these are issues on which we need to be reflecting. If we sort of extend the whole impact of the CRPD onto this criminal procedure code, I think that is something which requires way more attention. The most important thing that needs to be happening there is we need to acknowledge the fact that the criminal justice system would also be having people with disabilities as players in it, be they as witnesses, be they as complainants, be they as accused. And if that is the case, it's extremely important that we start to build in notions of accessibility of physical infrastructure, accessibility of communication, accessibility in terms of how we are kind of bringing in our norms and administering our systems. If the system is an acknowledgement of a person with disability, then it's one kind of a system. If it is not an acknowledgement of them, then it's a very different kind of a system. The CRPD, I think, requires us to be looking at the CRPC and the administration of criminal justice from that particular lens. When we teach that part of the code and we think about the impact of the CRPD on criminal responsibility, I think it's extremely essential that we should bring on board and we should reflect upon and highlight this issue. I would want to, in conclusion, sort of worry in terms of that, okay, how, if the entire thrust of my conversation with you today is that we have been transacting criminal law and transacting our teaching of courses, all courses, but today, because I'm specifically reflecting with you on criminal law, as if to say it is only to be addressing the concerns of the non-disabled people. People with disabilities don't really figure in our in the manner in which we teach this law, excepting when we are starting to talk in terms of specific provisions which are referring to people with disabilities. I think it is somewhere important that we start to bring in disability as an integral part of the human condition in the manner in which we are addressing questions of criminal responsibility and culpability, rather than only seeing it as an aberration. It's important somewhere that we individuate human beings rather than just seeing them as prototypes. If we start to operate in this kind of manner, then evidently the way in which we would address questions of criminal responsibility would be would move in a very different way. And this incorporation of persons with disabilities into the criminal justice system, I think, allows for humanizing of that system. One of the points I have been making with you throughout, in every time I have come to talk with you, is that as teachers, it's not our job only to be intellectually charging our students. It is as much our job to be building on their empathies, because only an empathetic law person is going to be striving for justice, which is one of the major concerns or one of the major goals or objectives of a law person, whether as a lawyer or a judge or as a teacher. And I think in inducting the disability dimension into the teaching of criminal responsibility or even criminal law, we would be able to communicate this to our students and equip them accordingly. To do a quick run-up of what I have done with you today, I was primarily looking at the whole question of criminal responsibility and how, for a longest period of time, we only saw it as a technical exercise to be finding out whether somebody can avail of the defense or can't avail of the defense. We saw the defense primarily as some kind of a benefit we were giving to people with disabilities. With the recognition of universal legal capacity, do we need to revisit this defense and see how should we induct people with disabilities into the criminal justice system, which is way more respectful of them? In answering or in reflecting upon this question, some of the philosophies which are the underpinning of criminal law could help us to decide which way we need to be going. I do hope that this is a conversation that we continue to have in relation to other areas of law or other issues that we would be discussing. Thank you so much.